Okay, Chapter 7, Parenthood. After reading this chapter, you should be able to identify the three parties most interested in parentage determinations, identify the most common ways in which legal parentage is established, describe the basic process for adjudicating paternity, explain what paternity fraud is and how paternity may be disestablished, identify various applications of assisted reproductive technology, discuss some of the ways in which courts and legislatures are addressing surrogacy arrangements, cryopreserved embryos, posthumous conception, and the uses of assisted reproductive technology by same-sex couples, and describe the role of the paralegal in cases involving determination of parentage. First up, identifying the three parties most interested in parentage determinations. Who are the three parties most interested? First, you have the child, whose interest is in knowing his or her parentage, has many emotional, social, economic, medical, and legal advantages for a child. The parents, although being a parent triggers economic obligations, it also brings with it the satisfactions of raising children. And the government, its interest is primarily economic, given the need to control the cost of public assistance. Identify the most common ways in which legal parentage is established. What are the most common ways? First, there is the marital presumption, the presumption that when a woman gives birth to a child while married or within 300 days of termination of the marriage, her husband is presumed to be the child's father. There's also an acknowledgement of parentage. The parents voluntarily acknowledge parentage by completing an appropriate notarized acknowledgement, stipulation, or affidavit. Adjudication of parentage, usually a civil action commonly brought by a mother or a 4D agency seeking child support, in which the court determines parentage, typically paternity, of a child based on evidence presented. Describe the basic process for adjudicating paternity. What are some of the threshold issues in paternity actions? Mothers, fathers, and 4D agencies are the common claimants. 4D agencies, for example, are going to be your child support enforcement agencies who would seek child support if a mother is receiving public assistance. So it's not always the mother who seeks child support. The mother can have no interest in the receipt of child support, and the state, as long as that mother is receiving any form of public assistance, the state can initiate its own proceedings to institute a child support award so that the state receives some portion of those child support payments for repayment of public assistance paid on behalf of the mother of the child. Subject matter jurisdiction may be concurrent in multiple courts. The court must have personal jurisdiction over the defendant. Venue is usually proper where the child resides. Statutes of limitation for bringing paternity actions vary by state and federal law. The burden of proving paternity is on the petitioner, and the standard of proof is usually by a preponderance of the evidence. Paternity judgments are binding on the parties, but not necessarily on the child. DNA testing is evidence, but it is not necessarily determinative. What's the basic process for adjudicating paternity? First, a complaint is drafted. You'll see a complaint form on page 219 of your text in Exhibit 7.3. You can also look at some of the forms that are available through the Franklin County Juvenile Court website. Care and custody disclosure form is prepared. If receiving public assistance or otherwise unable to pay, an affidavit of indigency is completed by the plaintiff. The plaintiff files the above and the court assigns a docket number or case number, and typically referred to as a case number in Ohio. Summons is completed and served. The defendant answers the complaint admitting or denying paternity. The court can take a default judgment if the defendant fails to respond. Financial statements are filed. Motions for temporary orders relating to the child may be filed and heard. If paternity is disputed, genetic testing may be ordered. Discovery is completed. Customary pretrial steps are completed. A trial is held, and then either the case is dismissed or a judgment is entered. Explain what paternity fraud is and how paternity may be established. First of all, what is paternity fraud? Paternity fraud is a fraud in which a mother intentionally misleads a man into believing he is the father of a child to whom he is genetically unrelated. Some examples may be where the mother may have been raped and not want contact with the father. There may be a history of abuse and she fears for the safety of herself and the child. She may be married and not want to jeopardize her marriage. She may lie because she has to identify a father in order to receive public assistance. How is paternity disestablished? Disestablishment of paternity refers to the situation in which a court issues an order vacating an earlier paternity judgment or acknowledgement of paternity based on evidence the man is not the child's father, in effect disestablishing a previously existing father-child relationship. The states have taken 3 positions on the issue. A number of states have determined by statute or case law that in the interest of fairness, a father who has been defrauded should be permitted to seek an order vacating an earlier paternity judgment. Some states have expressly not permitted disestablishment petitions, viewing the child rather than the father as the victim. The remaining states weigh the relative benefits of knowledge of the truth against disruption in the child's life. Identify various applications of assisted reproductive technology. What is assisted reproductive technology, or ART? ART refers to treatments or procedures designed to make parenthood possible for persons with fertility problems or individuals who are otherwise unable or personally unwilling to reproduce. Some of the more common methods include the following. Artificial insemination involves insertion of the sperm of a donor into a female's reproductive organs by a means other than sexual intercourse. Cryopreservation is the freezing of, I can't remember how to pronounce these anymore, gametes, which are egg and sperm or embryos to preserve them for use at a later date. Embryo adoption, 2 or more embryo donors give an embryo to a recipient with the intention that the recipient become pregnant and subsequently adopt the resulting child post-birth. IVF, or in vitro fertilization, the fertilization of an egg by sperm outside of the womb with the intention that the resulting zygote be available for implantation, cryopreservation, donation, or research. Posthumous reproduction, reproduction that occurs after the death of one or both of the gamete contributors. Surrogacy, in a surrogacy arrangement, a woman agrees to conceive a child through natural or artificial insemination or to implantation of an embryo and to relinquish her parental rights to the resulting child post-birth. The surrogate mother may or may not be genetically related to the child. Some of the ways in which courts and legislatures are addressing surrogacy arrangements, cryopreserved embryos, posthumous conception, and the uses of assisted reproductive technology by same-sex couples. Surrogacy law is unsettled, and some states have no controlling statutory or case law. Some states ban surrogacy agreements entirely, and others regulate them to varying degrees. When disputes about parentage arise in the surrogacy context, the courts generally apply one of 4 standards. Genetic test. Individuals who contribute the child's genetic material should be the legal parents. Those who use the gestational test. The woman who carries and gives birth to a child should be the child's legal mother. The best interest of the child test. The legal parents should be the persons best able to meet the child's needs. Intent test. The legal parent should be the person who put the procreative process in motion with the intention of being the child's parents. The courts will increasingly be called upon to address these cases as there are hundreds of thousands of unused embryos in cryopreservation. The unused embryos may be stored for use at a later date, donation, research, or ultimately destruction. There are 2 contexts in which this topic is most likely to arise: disposition of frozen embryos upon divorce, posthumously conceived children. A limited number of states have enacted legislation relating to the use, storage, and disposition of preserved embryos. The courts have applied 5 approaches when addressing this topic. In the absence of an agreement, the majority favor the party seeking to avoid forced parenthood. Other courts have just simply enforced the agreement. Others have enforced the agreements but allow the parties to change their minds up until implantation or destruction of the embryos. Other courts have enforced agreements but not for non-reproductive use unless permitted by state law. Others have refused to enforce agreements based on state law, public policy, or other considerations. How do the legislatures and courts deal with cases involving posthumous reproduction? Thus far, most disputes involving posthumous reproduction arise in connection with probate matters or claims for Social Security survivor benefits. So with probate matters, several states identify the intestate inheritance rights of the posthumously conceived children by statute. Some provide, along with other conditions, that the intended parents and treating physician must have signed an agreement regarding disposition of cryopreserved eggs, sperm, and embryos in the event of the death of one or both of the spouses. With a claim for Social Security survivor benefits, posthumously conceived children may be eligible for Social Security survivor benefits if the child is entitled to inherit under the intestacy law in the state where the decedent was domiciled at death. How do the courts and legislatures deal with cases involving children born to same-sex couples through ART? Initially, the courts generally determined that only the birth parent was a legal parent to a child born to a lesbian couple that had a child together through artificial insemination. However, there's an increasing trend towards recognizing parental rights and responsibilities of same-sex partners in some circumstances. These circumstances have been where the co-parent participated in the decision to have a child, the co-parent lived with the child since birth, the co-parent had an agreement with the child's legal parent to share parental rights and responsibilities. The co-parent held himself or herself out to others as the child's parent. Recognizing the co-parent as a legal parent will be in the child's best interest. Describe the role of the paralegal in cases involving determination of parentage. Paralegal's role is determined by the extent to which the firm handles cases involving parentage determinations, the prevailing law in the jurisdiction where the paralegal is employed. The tasks most commonly performed by paralegals include the following: locating controlling statutes and case law, researching related jurisdictional issues, gathering information in preparation for drafting pleadings, motions, discovery requests, etc., maintaining a list of reputable DNA test banks and arranging for testing when directed, drafting agreements such as surrogacy agreements, and drafting affidavits, exhibits, memorandum, correspondence, etc. as assigned. So that is your Chapter 7. Stay tuned for Chapter 8.